What's your advice to a party if you're going to be getting cross-examined during this restraining order hearing, during this custody trial?
This works so well. I'm reluctant to even share the information, but I've decided, no, it needs to get out there. Okay.
What is going on, everyone? This is Mark Reel Jr., the Fathers Rights attorney, and you are listening to the Fathers Rights Playbook. And on today's episode, I have senior trial attorney out of our Corona office, Brian Mayer. Brian, how are we doing today?
Great. I'm glad to be here.
Awesome. So today, what we're going to talk about is how you can be your own star witness in your trial. So, Brian, this is something that I think we probably, heading to trial, spend an inordinate amount of time with clients on how to make a good impression. So we're a couple weeks out from trial. You're sitting down doing trial prep with the client. What are the first couple of things you're going to go over with them?
Sure. So first of all, it's not just about being a good witness or star witness. It's about not torpedoing yourself, because I can't tell you how many times people go in there, and it's not just the men. How many times people go in there and they just destroy themselves?
You just watch it burn to the ground.
It is a train wreck in slow motion and is hard to watch. And any attorney who's done this for any period of time has seen it. It's terrible.
Your attorney is hoping you shut up. The other attorney is just hoping you keep talking.
Well, that's exactly right. And that kind of goes to the first point when we're talking about how to present well, which is the reality is that when you're talking, there's very, very little that you can say that's actually going to help your case. The more you talk, the more likely it is that you're going to say something that's damaging to your case. And the other side wants you to keep talking, because the more you talk, the deeper the hole you dig for yourself.
More details, more you can screw up, more you can confuse people. Most of the time, the more you talk, the more emotional you get.
Well, I think being in court is an emotional event, for sure.
Yes.
Okay, and oftentimes, I'd say most people, when they get to court, that's the only time they'll ever be testifying in court in their life. So they're not sleeping well. They have their emotions however it's related to the case. And I'm not even just talking about the parties. I'm talking about people who are drawn in as witnesses. If you've ever had stage fright, imagine being under penalty of perjury and literally being judged.
The bailiff sitting right in front of you. Just to your right is the judge. There's these attorneys sitting at counsel's table right in front of you. It can be intimidating.
Right. And so there's so many things that go into it. But I think the first and foremost thing that people need to understand is when you are in court, this is not like any other day in your life that you've ever had, nor is it like any conversation you've ever had in your life. This is not you're going to be asked questions and you're going to give answers, but this is not a conversation. And that's the first mistake that people make. And I'll give you an example. Okay. I say to you, hey, Mark, what time do you get off work today? Okay. Now, you may know the reason I'm asking is because my car's being worked on and I need to get a lift home. Yeah. So I say, what time do you get off work today? You could say the answer is 5:00, but because this is a conversation, you know where I'm going with this. You know what I'm thinking. And you say, oh, hey, I'll give you a lift home. I'll give you a lift home after work. Don't worry about it. Okay. You answered the ultimate question, but you didn't answer the question. And that's what people are accustomed to doing. They're accustomed to answering the ultimate question, or what they think is the ultimate question. But in court, you have to answer
ding, ding, ding.
The
what they
question.
Think.
Exactly.
Yes.
Exactly what they think is the ultimate question. And so in court, when you're answering anything other than the actual literal question that's being asked, you are shooting yourself in the foot. You are setting yourself up for further questioning, to be scrutinized further, and you still do not get around to the fact that you have to answer the question that's been asked in the form that's been asked.
And if the other attorney is any good, they're going to beat you to the spot anyway. They know what they're doing. You're not going to outsmart them from the witness stand.
You're not. And when it comes to that really kind of segues then into the next point, which is the attorney does this. If they're any good, if they've done it for any period of time, you are the 100th, 1000th, however many person that they've done this through. They've done this to, and they have making you look like a fool boiled down to a science. And you cannot underestimate the other attorney's ability to take your words and make them appear to be something that they are not. Now, I heard a professor at a professor at a law school. He was speaking and talking about he teaches trial advocacy, and what he said is, in his words, there is nobody that I can't make look like a fool on the witness stand. And that is just about true. Yeah. So when you are being questioned, okay, and you really need guidance from an attorney if you're going to be questioned, because if it's at all an option for you, it doesn't have to be us, but talk to somebody. You have to know what to expect. You need to know how the questions are going to be asked. You need to know what that's going to look like, because if you're not ready, there's no way you're going to do well. Anyone would crumble given the pressure that a skilled litigator can put on you in that context.
Death by a million pricks. They'll just systematically tear you apart.
Speaking for myself as a trial advocacy specialist, someone who's been doing this for almost 20 years, I will cut off your head and you will not even know you're bleeding.
Yeah. It's entertaining to watch, especially when seeing it's like where mom or dad, it doesn't matter who you are. They think they're smarter than the attorney that is on the other side, and they just systematically get made look like a fool over and over and over again.
Absolutely. And are we talking about specific strategies as well?
Yeah. So let's you go in. So let's start there. We're a couple days out from probably the most common trial we have, domestic violence restraining order trial. You've been accused of domestic violence, and they're requesting a restraining order. What are you going to tell that client about what's going to happen on that day, what to expect, how to respond?
Well, remember, as we said, this is not like any conversation or any exchange of information that you've ever experienced in your life. So there are different rules, and there are different expectations, and there are different interpretations of what you do. What might be appropriate in a normal conversation will project the wrong thing in court. So the first thing that you have to understand is that from the minute you walk into that courtroom, you are on the judge's radar. And in fact, even when you are not on the witness stand, oftentimes the judge can see you better, will observe you more, and get a better sense of your body language.
And not just the judge, the court reporter, the courtroom assistant, the bailiff. You think they don't talk when they go back?
And the other attorney is sizing you up as well,
yeah.
And that is absolutely true. You are on trial from the second you walk in that door. And the way you have to conduct yourself, you have to understand there are normal emotions, there are normal behaviors that we exhibit that will be misinterpreted. They may be completely appropriate in any other context, but will be misinterpreted there. If something funny happens, you laugh. Okay, that's normal. But if you do it in the courtroom, it will come across as flippant. Okay? Yeah. Best case scenario. Okay, you think this is a joke. Okay? So it's things like that. And my recommendation is you have to treat it like a funeral. You are at a state funeral. This is a head of state is dead, and you have TV cameras everywhere.
I'll say this. Hundreds of RFO hearings, DV trials, everything over the last 3 years. And only at one occasion have I seen a judge laugh during a serious moment. Hilarious line of questioning, involves some Facebook posts, but that's one of the biggest turnoffs for judges, I think, is when they feel like one of the parties doesn't care or isn't taking it seriously.
Oh, it's offensive. It is profoundly offensive to the bench. And it's not just that. when they are giving you this time for trial time is very precious to the courts. They don't have enough of it.
They're overworked, underpaid for what they're asked to do.
Their responsibility is tremendous, and they would love nothing more than for you to settle and for you to not need to be there. So if you appear to be less comfortable, if you appear to be more comfortable than you should be in this situation, if you appear to be enjoying this any more than they are, and they're not enjoying it, all right, that's offensive. Good for you. Oh, yeah. You're happy to be here? Well, I'm not.
Yeah, definitely. So we're treating it like a state funeral, and we're taking it serious. We are showing that. I always use this like this is at minimum the most important job interview you've ever had, because in family court, most of the decisions are based on what the judge perceives you are as a person, and they only get this small little window to look in.
That's right. They're not there when things are happening. They're not seeing what happened. They're not, if we're talking about custody related things, they're not seeing you interact with the children. If we're talking about domestic violence allegations, they're not seeing the actual act. They have to base everything on what they're hearing from you and how you're saying it. And it's not as simple as just going in there and being relaxed. I think it's even a mistake in most cases to even be assertive, because that can come across as domineering.
Especially with DVs.
Absolutely. So you have to have the right energy, and not just the right energy for a family law case, but for the moment and for the issues at hand. Because whatever your energy is, that judge will have an impression of you, and that impression will be influenced by everything from how you hold your shoulders, to how the words come out of your mouth, to how you process the questions that are being asked.
Yeah. So I'm curious, and because I have some opinions on this, but I really want to hear yours. So obviously you go up on the stand, you're going to get the questions that are easy, that can be somewhat scripted from your own attorney, but when the other side goes to cross-examine you, what is your advice for clients on how to answer, how to respond when a lot of times opposing counsel will take jabs at you, will poke at you, will try to get you to react?
Right. And so I'm going to expand on that a little bit, okay? First by saying I can't tell you how many times I see another party go up there, and their attorney asks them questions, and the answers are flowing, and they're saying exactly the right things, and then as soon as I start answering questions, they suddenly start stuttering, they trip over their answers, they can't remember anything, the answers don't make sense, because there's just something fundamentally different about questions that are structured to elicit an unfavorable impression from you or to help the other side that makes the flow of information become more difficult. So in terms of, and I'll tell you this, there's a proverb, one man's account sounds true and correct until another comes forward and questions him. And that's exactly what we do when we're defending our clients. We're asking those questions that get to the truth of what's going on, because that's what we're about, is making sure that truth comes out. But in terms of and I'm sorry, it was how do we
cross-examination? How are we answering? What's your advice to a party if you're going to be getting cross-examined during this restraining order hearing, during this custody trial?
Right. So that's a fantastic question, and I'll tell you what, this works so well. I'm reluctant to even share the information, but I've decided no, it needs to get out there. Okay. So that's how good this is, and I feel like this is the key. I really feel like this is the key to all of it, especially when it comes to domestic violence restraining orders. Okay. And here's what it comes down to. Okay. When I am asking questions of another party, I'll take the temperature of the room, I'll gauge them, but more often than not, I will go on the attack. Okay. Because that's usually what my client needs. We deal with a lot of people who are, if not outright wrongly accused, they are being framed in a light through a perspective that is just not, it's either not intentionally not genuine, or tainted by some other person's lens of reality. So, and that's oftentimes what attorneys do is they take that aggressive. We've all heard the pit bull attorney metaphor, okay? But what I've found works in this situation is when people are being confronted, when people are being attacked, whether verbally or physically, when they feel threatened, they respond in one of two ways. One thing that they will do is they will get bigger. And what I mean by that is you're approached by somebody, they're aggressive, they're attacking you, you match or exceed their energy. They get loud, you get loud also. They puff up their chest, you puff up your chest. They start gesturing and swinging their fists around. You match that energy, you push back.
Yeah.
You get bigger. We see this in the animal kingdom. Okay, an animal feels threatened, their hair puffs out, they show their teeth, they growl. Okay, they get bigger. Or the other thing that people do is that they retreat. They get smaller. They hide. Oh, I'm so sorry. They get meeker. They get quieter. They present instead of sending the message, "Don't mess with me because I can fight back," they send the message, "Don't mess with me because I'm of no threat to you." And we see this in the animal kingdom as well. We see the armadillos roll up into a ball, turtles tuck into their shell. They hide animals will hide in their corner. And so what people need to do on the stand, there's only one truly good way to deal with this. When you are accused of when you are in a domestic violence case, when the other attorney is attacking you, they are intentionally trying to elicit an aggressive, defensive, emotional response to you to demonstrate to the judge that you are the type of person who reacts in that way. They want a reaction out of you. They need a reaction out of you to win your case. And when you go into it knowing you're going to be attacked, when you go into that case and you are prepared to get smaller, to shrink down, to become meeker, to send that signal, "Don't hurt me, I'm of no threat," it is like letting the air out of a balloon with the prosecution, and there is nothing that they can do about it.
Awesome. That's deep on the thought there, in terms of, but it makes perfect sense because especially when we have defending restraining orders with men, the last thing we want to come across is being an aggressive person. Because the judge can then correlate that to, okay, I could see them being aggressive. I think the other tip, and I want to get your opinion on this, is you answer the question in as few words as possible when the other side's asking it.
Answer the question, two things. First, listen to the question. And number two, answer only the question. Because when you answer first of all, you're going to answer the question in the way it's being asked one way or another. But anytime you give information that is not being asked, you're just giving more opportunities to allow another issue to come up, for something to be misinterpreted, to go down an entirely different line of questioning that you weren't expecting. And I'll tell you about I'll share a case with you. This is where it really clicked for me. Is I was defending a domestic violence restraining order a couple of years ago. And we had, I was representing the husband. And what happened was he came home one day and his wife, they had two little kids. They were, I think they were 7 and 5. He came home one day and the wife said, "Hey, guess what? I'm taking the kids. We're moving to Texas. I don't know when or if we're going to be back. Say goodbye. We're leaving right now." Completely caught off guard. He simply wasn't prepared for it. He's in a panic. He's trying to say goodbye to his kids. He doesn't know what's going on. And in the midst of this chaos, simply being unable to express himself in any other way, he punched a hole in the wall. Okay? There was no debate that this happened. And it was kind of scary, honestly, but you consider the context of what was happening at the time, it kind of makes sense that he had this response. So we get to trial, and we're not denying that he did this. We're not denying it. Mm-hmm. So I'm asking the wife about it, and she said, and I asked her the question, is this the only time he's punched a hole in the wall? And she said, yes. But then she added, this wasn't like him at all. Now, I didn't ask him if this was like him at all. I didn't ask that question. I just asked the question, has he ever punched a hole in the wall before?
Yeah.
She said, yes. The answer was yes, and she could have left it there. Now, we prevailed. The restraining order was not granted.
And it was probably that one little phrase.
I don't know to what extent it impacted the final decision. I don't know if it was determinative or not. But when the judge was explaining his rationale for declining the restraining order, he specifically said, she even said, this is not normally like him. Now, I don't know if we still would have won without that or not. I'll never know. There's no way the judge didn't tell us, so I wouldn't know. But had she kept her mouth, had she just answered the question and only the question, she would have, that would not, at least that would have not happened. It would not have been a factor in the court's decision. And the problem is that people want to tell their stories, but you're not there to tell your story. You're there to answer questions.
Yeah.
Our job as your attorney is to tell your story.
Yeah, very true. And I think that's a really good spot to end on. Thank you, Brian. A lot of really, really good information about testifying in court. To our viewers and listeners, thank you again for watching or listening to another episode of the Fathers Rights Playbook. We'll see you all again next week.